Good afternoon, everybody. My name is Jeff Stauffer, Community Relations Director with Elville and Associates, and welcome to our webinar today with our presenter, partner and senior estate planning attorney, Olivia Holcombe-Volke of Elville and Associates. Olivia may have a few additional words in a few minutes to say about herself, but I'll say that our clients think the world of Olivia, and her extensive experience speaks for itself. The care and time she takes with her clients. Of all the attorneys that we could have chosen from my entire family, as far as taking care of our estate planning, I had Olivia work with my family over the years. So I think that certainly says something right there about time and the care she takes with our clients and about the work that Olivia does. So the first time we've done this in one of our webinars, so let's see how it goes. We're going to start with a poll to gauge where you are with your estate planning, how that compares with people around the United States. So I'm going to launch that now, and you should see it pop up on your screen, and it should just take a few seconds to answer and submit your response. So I'm going to go ahead and launch that. So let's give that a go. I'm going to go ahead and launch it. Oh, there it is. So what is your current status as it relates to your estate planning? You can select one of those choices, and it should, I think once you click on it, either closes it out or gives you the option to submit it. So curious to see what type of demographics we have joining us today. So we're glad you've taken the time to join us. Education of our clients and the communities we serve is part of our practical mission here at our firm. And we want to keep that going during this time that we're all facing together apart. So in this time of uncertainty, you can be certain that the firm is going to be here for your family and you to answer any questions, offer education, and be a resource to you in any way that you need us. Just a minute about our firm, if you're not familiar with us. We were founded in 2010 in Columbia by President and Principal Attorney Stephen Elville. We have a number of different practice areas and services that we offer, including estate planning and special needs planning, elder law and elder care planning, estate and trust administration, asset protection, guardianship, tax planning. We also have an attorney here that does focus a lot on SSI and SSDI and those types of benefits that many people have a need to have an attorney help them qualify for. We do have 7 attorneys here, 12 staff members, and 5 locations. We're coming to you live from the Columbia office today. Our mission is to provide practical solutions to our clients' needs through counseling, education, and the use of the very best superior legal technical knowledge available. And you hear that word education a lot, and we really mean it when we do focus on education here. And we do that in a number of ways through our planning process with our clients, through over 100 educational workshops in the communities that we serve each year. And my phone is ringing, and sorry about that. I'm gonna reject that for right now. And also lastly, by way of our accredited client care program that many of our clients take advantage of for additional benefits and educational information that we offer them throughout the year. It is my pleasure to welcome Olivia Holcombe-Volke, partner and senior estate planning attorney with Elville and Associates. She is our presenter today, and we're glad to have her here and thank her for her time. Olivia addresses all aspects of estate planning, the initial drafting of wills, trusts, advance directives, and powers of attorney, as well as the revision and updates of those documents as life changes occur. She works with clients who have elder law and special needs concerns, whether that be on behalf of themselves or a family member, works with Medicaid and veterans asset protection efforts, special needs planning, and the difficult issues attendant to mental and physical incapacity. Many different activities and honors for Olivia. She's very well versed, named to the Maryland Rising Stars Super Lawyers list in 2017. Named 10 best for client satisfaction in estate planning by the American Institute of Legal Counsel in 2018 and 2019. And I think what speaks most to Olivia's character and professional work is her volunteer work. She is a board member for the Women's Law Center of Maryland, along with being the chair for the Judicial Selections Committee, a volunteer attorney for the Maryland Volunteer Lawyers Service, as well as a founding member for the MVLS Community Advocacy Network, named Volunteer of the Month for the MVLS in May 2019. And a lot of attorneys look up to her. She provides training to volunteer attorneys on advanced directives, financial powers of attorney, wills, and deeds. So you're in good hands today with Olivia. Looking forward to hearing her talk about estate planning for young families, and I'll go ahead and turn it over to her. So thank you very much. And it looks like,
thank you.
Before we get started, sorry, Olivia, we have the answers to our poll. Looks like most of you did vote. It looks like just over half, 53%, do not have an estate plan in place. 24% have an estate plan in place, but it needs revision. And then the other quarter, 24%, have planning that's in good shape and are here for education today. So thanks to those that participated, and we appreciate that very much.
Excellent. Thank you so much, Jeff, and hello, everyone. Jeff, one thing, it says that the organizer must close the poll to enable screen sharing. So I don't know if you'd like to close out the poll.
Yep, there we go.
Very good. All right. Well, hello, everyone. Thank you for that introduction, Jeff. My name is Olivia Holcombe-Volke, and I appreciate all of you joining us during your lunchtime today. I know lunchtime means something a bit different now that most of us are working from home, but in any event, I appreciate you taking a moment out of your busy day to join me and let me walk through a bit of estate planning topics and context with you all, specifically with regard to young families. So I do want to emphasize before I get started, estate planning is a rather vast term and subject area. There are a lot of different things that fall within estate planning, from the most simple to the most complex. I will not be covering all topics that are relevant to estate planning as a whole, but rather really trying to focus on what estate planning concerns and subject areas are really the most relevant, particularly for young families or for young people who have never really gotten around to doing an estate plan. So I will be focusing on that, but I'm certainly well-versed and open to answering questions on a variety of topics. So let's start by taking a walk down worst case scenario lane. Sounds like fun for a Wednesday at lunchtime. Worst case scenarios. 1, you lose your mental capacity and your spouse has got to go to court to get permission to help you. 2, you are in a persistent vegetative state and your spouse and your parents disagree on whether to continue life support. 3, you and your spouse both die and your family members end up in court arguing over who should be the guardian for your minor children. Now, realistically, the worst case scenario should be limited to losing mental capacity or being in a persistent vegetative state or dying. That should be the limit of the worst case scenario. To add to that, to add to the grief or the horror of that by having the court be involved, family members fighting, none of that is something that should be added to what is already an incredibly difficult situation. Now, to talk a bit about some common misconceptions, and these are things that I hear regularly. Number 1, I have no estate for which to plan. I don't have any assets. I'm just starting out. I really don't have wealth. Or, I'm married. Everything will automatically go to my spouse. My spouse will be able to handle everything for me. The fact that I'm married means we don't need to worry about estate planning documents. Estate planning documents are only for people who are single or older or who have a lot of money. Or my fill in the blank, parents, siblings, friends have already told me that they will take care of my children. These are common misconceptions that lead people to believe that they don't actually need to have estate planning documents. And I'm going to walk through with you why all of those are misconceptions. So let's talk a bit about what estate planning actually means, because often people are aware of estate planning in terms of what happens to my stuff when I die, but they are less aware or less concerned about the aspect of what happens to me and my health and my property if I become incapacitated. And that is part of what estate planning accomplishes. It not only deals with the disposition of your property at death, but it also addresses who will manage things for you and how if you are still alive, but you lose your mental capacity. And of course, very important to our topic today is the fact that estate planning is also necessary for designating guardians for your children. So let's start by talking a bit further about incapacity planning. And when we're talking about incapacity planning, an important thing to emphasize is the term guardianship. Now, people are often familiar with the term guardianship in terms of their minor children, meaning if I die before my child is 18, which is the age of majority under the law, if I die before my child is 18, who will be my child's guardian? And that is true. That is a relevant use of the term guardian. But there are also adult guardians, guardianship of disabled adults. And that is relevant when there is an adult who is over the age of 18 who loses their mental capacity and has not signed any documents designating another person to be their agent, to have the authority to act on their behalf. If that happens, it becomes necessary for a spouse or anyone else to seek court-ordered guardianship over the incapacitated adult in order to be able to do things on their behalf with regard to their health and health decision-making, and also with regard to their assets and being able to access and manage their assets in order to pay for their expenses and their bills. So the documents that are necessary, absolutely vital, in order to protect you against the risk that you would ever be subject to court-ordered guardianship, are called the Advanced Medical Directive, and I'm going to talk a little bit about what that covers, as well as the MOLST and Healthcare Decision-Making Worksheet. And then with regard to finances, covered by powers of attorney, a Maryland statutory form, and an additional durable general form. So avoidance of guardianship simply means you, while you have mental capacity, signing the necessary documents to designate your agent, and it is very important to name successor agents, and then to be able to actually outline what you want that person to do for you, whether with regard to the decisions that they make regarding your health care and with regard to what powers and authority they have with regard to your assets and what it is that they're actually able to do. And so by signing the necessary documents, you are maintaining autonomy in the event that you actually lose the ability to make decisions for yourself. You've gone ahead and designated the person and the backup people who can act for you, and you've outlined what their powers and authority are. So healthcare decision-making. In Maryland, this is covered by a document called the Advanced Medical Directive. In some states, it's referred to as a healthcare power of attorney. The Advanced Medical Directive does not have a required format, but the Attorney General created an excellent form that is really the guiding point for all estate planning attorneys in working with their clients to create an advanced medical directive that's individually appropriate for each client. I will talk about not only the more clinical aspects of what an advanced medical directive covers, which are very important, but also some of the extra details that I always recommend that people put some thought and time into. The reality is most of us, particularly at younger ages, have not spent a significant amount of time thinking about end-of-life decisions or end of life. And that's good. That means that you are living your life and you are hopefully enjoying it and not spending too much time thinking about such dire things as end-of-life conditions. But it is important, and I always try to emphasize, when you're doing estate planning, none of it is pleasant, none of it is fun, and when you add to it that you have to pay for it, boy, no wonder people don't get around to doing it, sometimes ever. But the fact is that by doing an estate plan and by paying for the estate plan and getting it into place, you have done everything that you can to prepare for the worst and to protect yourself against the worst, which will then allow you to put the documents away, to know that you're ready for whatever may come, and then to go back to actually living your life and enjoying it to its fullest. But you've done what you need to be ready for the worst. So prepare for the worst case scenario and then live for the best. And another piece that I have to say now, I would be remiss if I did not mention this. When you do an estate plan, it is important that you update it regularly. So unfortunately, doing it once does not mean you're done forever. When you do an estate plan, I always recommend that you do it in terms of what if the worst case scenario happened in the next 3 to 5 to 7 years? What are the decisions that would be relevant if it were to happen during that period of time? Because you really should update and revisit the documents about every 5 years in order to capture changes in the law, but also changes in your opinions, your preferences, and your plans. So back to the healthcare decision-making and the advanced medical directive. Part of the reason that that's relevant is that it is quite likely when you are thinking about end-of-life decisions at the age of 30, you may have very different instructions and very different feelings than you will have at the age of 85. So the advanced medical directive allows you not only to appoint agents. Again, this is important even if you are married. Appoint your spouse, if that's who you want, to be your primary agent. But then go ahead and have some backup agents. Because what if something happens to both you and your spouse? You're both incapacitated, you're both unable to make decisions. You want to make sure that you've got at least one backup agent, if not 2 or 3. And again, when you're thinking about doing this document and you're thinking in terms of what would be relevant in the next 5 to 7 years, often when I work with younger people, they say, well, I would name my parents or I would name my sibling, but by the time this is relevant, they'll be older too, or they won't be alive. That's not the way to think about it. The way to think about it is, who is the appropriate person who I would want now and in the next 5 to 7 years? So appointment of agents, and then effectiveness of power. The document allows you to dictate, is this an immediate power that my healthcare agent can advocate for me at the instant they need to? Or is it contingent upon doctors actually certifying that I'm incapacitated? And that's an option that you have for the document. Then there are the end-of-life decisions. People have heard frequently of a term called the living will. The living will refers to you giving instructions regarding healthcare treatment in certain end-of-life situations. In Maryland, it's broken into 3 distinct categories. They have overlap, which can lead to some confusion, but they are defined as a terminal condition, a persistent vegetative state, and what's called an end-stage condition. And again, I have to keep hammering home, as much as we all have an idea of our life cycle and the fact that it will follow the timeline of us all achieving a ripe old age and then hopefully just closing our eyes and that's the end. Don't think about things like persistent vegetative state or end stage condition as only falling on older people. Unfortunately, we do not know what the future holds, and these are all realities that actually could happen to any of us at any time. Clearly, the current situation that we're all dealing with globally really hits that home. So as you're working through end-of-life decisions, as painful as it is, it's important to think about it as right now and not 60 years from now. So those are the decisions that go into the living will and that allow you to actually dictate, would you want to be hooked up to a ventilator, or would you simply want to be kept comfortable? And there are nuances to all of that, which would be part of the counseling you would receive with me or any other estate planning attorney. Personal preferences is where it really goes beyond the clinical. So the Advanced Medical Directive, at its core, it's intended for you to be able to designate an agent who has the authority to tell the doctors what to do, and it's intended for you to be able to actually give instructions regarding those certain end-of-life situations. But the personal preferences and the food, entertainment, visitations, those are things that people often don't take into account as quite relevant in terms of what if you are ever in a situation where you are no longer able to communicate? Will the people who are involved and who are managing things for you, will they know that it's important to you to not be in a room with the television on all the time, or to maybe have vanilla ice cream if possible, or to listen to a particular type of music? Those are personal preferences which are different for everyone, and as well as we all know ourselves, other people may not know that about us. And the Advanced Medical Directive does provide some space for being able to customize and write in those types of personal preferences. But I always recommend actually thinking about writing a separate letter of instruction, or letter of intent, or letter of wishes, where you actually go into a bit more detail on a personal level to the people who might be managing things for you in the event this ever happened, to let them know those sorts of details that are really not clinical, but quite important to you personally. There are flexibility options built into the Advanced Directive. So Maryland actually allows you to say, these are my instructions. However, I am giving my healthcare agent the discretion to make a different decision in the moment if they believe that it's in my best interest. So you actually have the ability to give your healthcare agent some discretion, or you can choose to say, absolutely not, they must follow my instructions, no discretion. And that's also a difficult decision to make for you, and something that I really spend time talking through the pros and cons of each option. And finally, the Advanced Medical Directive allows you to dictate your organ donation preferences and your preferences with regard to final arrangements, although that's another area where I always recommend, as a part of that separate letter of instruction, go into more detail about your vision of a celebration of life and what that might entail, or whatever else you might have in mind. Again, for many people, especially young people, it's not something you've spent a significant amount of time thinking about, and I applaud that. I think that's very healthy. But it's also a good idea to take a little bit of time to think about it, put it into writing, and then you don't have to think about it again, at least not for another 5 to 7 years.
So Olivia,
Yeah.
Before we move on, if we could take just a pause to answer a couple of questions.
Absolutely.
You alluded to thinking about unforeseen circumstances and somewhat worst case scenarios. We did have a couple of questions related to life insurance, which I thought were good ones. I'll actually ask both of them at the same time. When should young married couples get life insurance, and what types do you recommend? And then the other question was, at what age do you recommend getting long-term care insurance?
Excellent. Thank you, Jeff. And those are both excellent questions. The reality is that what I am able to comment on as an estate planning attorney is that it's a good idea to think about those forms of insurance and speak with someone who's an expert in those forms of insurance, whether it's an insurance agent or a financial advisor. Because the reality is, especially with long-term care insurance, it's making a decision about investing and really where your money is best put at this point in life, insofar as investing your money in some vehicle like long-term care insurance. So that's really more of a financial advice, I think, financial advisor input. I will say that life insurance does tend to be more appropriate and important for young couples, young families, especially with children, because one of the big parts of its purpose is to replace the income stream that would be lost if a spouse died, particularly when there may be a mortgage or young children. So life insurance is very relevant, but when to purchase it, in what amount, under what terms, those would all be questions that would be really appropriate for an insurance agent or a financial advisor. But the good thing is that by working with me or any of our attorneys, we're able to connect you with people who have those answers and who are able to give you excellent guidance on all of those questions.
And along those same lines, Olivia, which I think you probably answered this question just now, do you recommend disability income insurance for all persons whose income is important for the family?
So again, that would be something that would really be more appropriate for an insurance agent or a financial advisor. But speaking personally, yes. Yes. I think it's a very important thing to be aware of if income, a stream of income, were lost. And whether that's relevant to the death of a spouse or a parent, or whether that's relevant to the incapacity, disability of a spouse or a parent, it is something to be taken into account. What would we do and how if this income stream were gone? So I absolutely think that those are relevant things to be concerned about and to be thinking about and to wrap into the conversation and the thought process at this stage of life.
Very good. Thank you, Olivia. Keep those questions coming, everybody. Thank you.
Yes, please. Absolutely. Okay. So we talked about the Advanced Medical Directive. That's specifically with regard to your health care. Now the financial aspect. So financial powers of attorney are the documents that allow you to name another person to have the authority to access your bank account, deal with your 401k, manage your house, any of your assets, in order for someone who is not an owner of the asset to have access and be able to do what needs to be done with the asset. There needs to be a financial power of attorney document in place. And again, even if you're married, so my 401k, if I became incapacitated and did not have a signed power of attorney, my spouse would not be able to do anything with regard to that. So a financial power of attorney, for us and for the clients with whom we work, we provide two documents that constitute and cover all of the bases with regard to a financial power of attorney. And something that I want to emphasize as well here is that a financial power of attorney is only valid while you are alive. So the purpose of it is for you to give someone else the authority to do what needs to be done with your assets while you are alive. They are also supposed to only do so for your benefit. They are acting in your interest. So giving someone power of attorney does not mean that you are giving them the authority to take your money and run. They would be violating the law if they did that. you are giving someone power of attorney to act on your behalf in your interest. The two documents that we provide for clients and that we recommend, the first is called the Maryland Statutory Form. And the reason it's called that is because it comes directly from Maryland statute. The legislature about 10 years ago recognized that there was no standard form, and as a result, many people were writing their own, and many banks and other financial institutions were rejecting them, which then left people unprotected and exposed to guardianship. So the legislature stepped in, they created a standard form, and in the statute it says if you use this form and you do not change the writing, it is mandatory that banks and other financial institutions accept it. So it's extremely powerful, but it's also limited in how much we are able to customize. So the Maryland Statutory Form, Personal Financial Power of Attorney, it allows you to name the agents. So this is the person who has the power of attorney to access my assets for my benefit. And of course, again, I highly recommend that you name backup agents so that you're fully protected in case one of your agents is also unable to act. It covers a general statement of powers, basically saying my power of attorney can step into my shoes and do what needs to be done. Opening and closing accounts, buying and selling assets, signing contracts and tax returns, all of the things. Except it doesn't cover everything, and that's why we do a second power of attorney as a supplement. And I'll talk a little bit further about that in a moment. But the Maryland Statutory Form appoints your agents, gives a general statement of the powers that they have, and then it talks about effectiveness. And this is another big area that really catches a lot of people because most people assume that a power of attorney is only effective when they are incapacitated. That is actually not true. It is most often used when someone is incapacitated, but it's actually effective immediately. It's effective the moment that you sign it. That does not mean that the person that you've named as power of attorney now has full control over your money and you have no control. That's not what it means. It means that you both have equal control. Only you can do whatever you want with it, and your power of attorney is simply supposed to act in your interest on your behalf. But that can sometimes be relevant even if incapacity is not part of it. And two examples that I frequently use, one, if you're traveling and you're out of the state or out of the country and something local needs to be signed, well, it could be useful that you have a power of attorney that's immediately effective. They could do that for you. Another example, which is not as relevant particularly for young people, but for older people, especially during this time of COVID, what if you don't want to leave the house or you're not comfortable leaving the house? Your power of attorney would be able to go out into the world and go to the bank for you or go to wherever you need them to go to sign something or access the money or do whatever needs to be done. So it can be useful to have it be effective immediately. But not everyone is comfortable with that, and it's not mandatory. It's the default, but it's not all that's allowed. So we can customize it to render it effective only upon incapacity. And again, that's just a matter of counseling and talking through each client's specific preferences and concerns. Durability simply means that it will last even if you do become incapacitated, which seems like a very silly statement, but it is something that's required under the law. The statement that this power of attorney continues to be effective even if I do lose my mental capacity. The Maryland Statutory Form allows for very limited customization. And again, it's mandatory that it be accepted by financial institutions, but only if it has not been changed. The second power of attorney document that we provide and that we recommend for clients is meant to supplement the Maryland Statutory Form. And very briefly, the purpose of it, the Maryland Statutory Form covers 95% of situations, but there are a few situations that are not covered. and that we in our practice have seen necessary in certain situations. And so we have clients sign a second supplemental power of attorney that's meant to be used hand in hand with the Maryland statutory form. And that second supplemental power of attorney covers those additional provisions and additional powers, including compensation, which is not covered under the law. But we recommend that it's something that you do provide for in the event your power of attorney is having to spend significant time acting on your behalf. You want to make sure they have some way to be compensated, or else they may quit being your power of attorney. So again, it's just a matter of having the opportunity to be counseled on it by me or another attorney in order to decide what makes the most sense for you and your circumstances.
So Olivia,
Yes.
related to the financial power of attorney and the acceptance by financial institutions, we did have a question. And the question is, we have a mutual fund that will only honor a financial power of attorney if it is less than 60 days old. Seems like an onerous requirement. Have you ever heard of this kind of time limit on a POA? And do you have any recommendations on how to deal with it?
So that is very disturbing. I could not agree more. The reality is that there are some financial institutions that have put some parameters on their requirements that are extremely onerous. And often what we're faced with is, do we play along with their rules or fight their rules? And as I'm sure all of you know, particularly when dealing with large financial institutions or corporations, sometimes it's just easier to go along with what they're saying they require than to try to fight it and prove them wrong. So I'll say that as a starting point, which is that I think that if it were ever actually brought to court, I don't know that the financial institutions would get away with some of those types of games or requirements. But it is what it is. And with regard to how fresh a document needs to be in order for it to be accepted, in the law, there is no hard and fast rule regarding that. As a good practice, what I said earlier about updating your documents about every 5 years, that is based upon the fact that we have found it frequently can be presented as an issue if a power of attorney, for example, is considered stale. And frequently it seems that that is a term that's used when a document is more than 5 years old. It opens the door to the risk that the financial institution or whomever is going to say that this document is stale and therefore not valid and won't be respected. So it's a good practice to update documents at least every, 5 years is a good rule of thumb, and that protects you against the risk of that argument. 60 days is unbelievable. I don't have any idea what it is that they could be referring to when they're telling you that. I suspect that there's something more nuanced there because perhaps what that is indicating is that they have to receive the document that has been signed within 60 days. Basically, that there are some states where you have to submit a deed for recording within 30 days of it being signed, or you have to get a new deed signed. Maryland is not one of those, thankfully. But that may be an example of what that means, but I would say that would require a bit more investigation on my part and actually understanding a bit more of the detail. But ultimately, I will say that there are some financial institutions that want to have their own power of attorney form completed, but frequently it's something that can be done hand in hand with the Maryland statutory form, because again, under the law, it is mandatory that financial institutions accept that document. It's just deciding how much of a fight the client wants to deal with or go through. So I know that was an extremely convoluted answer, but ultimately what I would say is I think that particular situation probably has a bit more detail to it that I would need to know. But yes, that there are some complications that financial institutions, especially the big ones, can throw in the way.
Thanks, Olivia. And before we move on, one more question regarding powers of attorney. Can you do a durable power of attorney only rather than doing both? This is the first time I've heard of the personal financial power of attorney. I've only heard of getting a durable power of attorney in the past.
Sure. So good question. Several things that I would say about that. First of all, that's one of the reasons a lot of people have come to us with documents, or maybe their parents or their grandparents or whomever, that they've got documents that are old enough that they predate when the Maryland statutory form was implemented. So often people come in having had experience doing just kind of a general durable power of attorney, and they're not familiar with the Maryland statutory form. And part of that is because it did only come into existence in the last 10 years. Another thing that's important to emphasize is that the term durable and the term durable and the term general, what does that mean? Well, durable simply means that there's a provision in the document that says this power of attorney will survive my disability or incapacity. So even if I become incapacitated, this document will endure. It is durable. So that's a requirement, actually, that be written into the document. And that's true in the Maryland statutory form. It is durable. And that's also true as long as any power of attorney form has that particular statement that this power of attorney survives my incapacity. So that's all the word durable means. And general simply means it covers comprehensively the powers that someone may have acting as power of attorney. The alternative, the distinction is sometimes people sign a limited power of attorney. A limited power of attorney means I, Olivia, am going to be out of town when the settlement on my new house happens. I am signing a limited power of attorney to give this other person the limited power. Only on this date or this month are they allowed to exercise this power, and their power is limited to signing the purchase documents on the purchase of my new home. So that's what a limited power of attorney is. A general power of attorney does not do that. It covers at any time that it's needed for basically any power. So to get back to this person's question, ultimately, I would recommend the Maryland statutory form is step one across the board. And the reason is because of that mandatory acceptance. If you have a power of attorney that's durable and general, that's great. But if it's not the Maryland statutory form, it does not have the power of the statute saying that it's mandatory that it be accepted. So it's just, it's not that it won't work. It's just that we recommend go ahead and have that extra authority of the statute saying if it's this form, it's mandatory that it be accepted. Now, of course, with the caveat of the fun that financial institutions can sometimes throw in the way of that. But generally speaking, that is step number one. So I hope that helps answer the question. Any further questions right now, Jeff?
Not right now. All great questions. Thank you. I think we can move on.
Okay. All right, so the screen that we're looking at now really talks about the basic estate plan that is fundamental. And really, I would say this is the fundamental estate plan for anyone over the age of 18, but especially when you start to add in being married or having young children. So the fundamental estate plan is made up of the powers of attorney that I talked about, the advanced medical directive, and I apologize, let me just quickly say what the MOLST is. In terms of if you want to be resuscitated, so if you were to ever be in a situation where you coded and you had preferences on whether to be resuscitated or not, that is not covered by the Advanced Medical Directive. That is something that is specifically covered by what's called a medical order regarding life-sustaining treatment, and that's called the MOLST. And if you work with an attorney who can really help guide you through all of these decisions, part of what I do is talk about the MOLST and recommend that it be something that you discuss with your physician. So a fundamental estate plan is made up of financial powers of attorney, the Advanced Medical Directive, and at the very least, a will. And I'm going to talk hopefully everyone can still hear me. That was something odd just happened. Technology is amazing, but it's not imperfect. Or it is imperfect, rather. All right, fundamental estate plan has to include at least a power of attorney, an advanced medical directive, and at the very least having a will in place. So let's talk about the last will and testament. All right, the last will and testament. When does it actually apply? Well, it applies at death, obviously, so we know that. It's not something that applies before death. It applies at death, but it also applies only when there are actually assets that are individually owned that do not have a beneficiary designation. And so that's an important thing to emphasize. If you own assets jointly with your spouse or another person, or if you own an asset individually, but it has a beneficiary designation, such as life insurance, 401k, IRAs, those types of assets have a beneficiary designation. And as long as that is properly completed, that is where that asset will go at your death. So a will is a document that dictates what you want to happen to your assets at death. But it is only relevant to assets that at your death do not have a beneficiary designation and that are not jointly owned with someone else. So for most assets that you jointly own with your spouse or with another person, at your death, that asset will be owned by the other owner. The joint owner will become the sole owner. So a will only controls assets that do not fall under those categories. So if someone dies and they have an individually owned asset and it does not have a beneficiary designation, what has to happen at that point in time is for that asset to go from the deceased individual owner to the recipients, the inheritors. It has to go through what's called probate. And probate is where the last will and testament is relevant. The last will and testament is what controls where the probate estate goes. Probate is a court process. So it is something that it's important to talk about what it means. It's important to talk about whether it's something that it's really important to you that you avoid. And I always laugh about that because, of course, you're going to be deceased. So you're not avoiding it for yourself. You're avoiding it for the person who's going to be taking care of things for you after you're gone. But I'm going to talk a little bit more about what it means to avoid that on the next slide. But first, again, a will is a document that says what you want to happen to your stuff, but it's only relevant to your probate estate, and your probate estate is made up of assets that are individually owned by you without a beneficiary designation. Now, a will is also extremely relevant with regard to the guardian of your minor children. And so this is the document where you will actually designate who you want to be appointed as the guardian of your minor children. That is something that is accomplished in a will. So subject to probate, talking a little bit more about that, it simply involves opening up the estate with the Register of Wills, going through the probate process, which involves an inventory that has to be filed of what assets are part of the probate estate, allowing time for claims from any creditors to whom you may have owed money, filing an accounting to show the Register of Wills what's gone on inside of the estate. And there is cost, and the cost is primarily made up of having to pay the probate court because they don't work for free, and having to pay for the help of filing final tax returns, the assistance of an attorney with the probate matter, and all of those sorts of costs that come up with that. Now, I say that a last will and testament is part of a fundamental estate plan. I say that because it is absolutely vital that everyone over the age of 18, at a minimum, have a last will and testament. It is absolutely important and vital to at least have a last will and testament rather than nothing at all. But sometimes people say, well, I would really like to make sure to avoid probate. And the answer to that is to do what's called a revocable living trust. So briefly, a revocable living trust avoids probate. That is its point. That is what it accomplishes. It does not give you asset protection. It does not avoid taxes. It avoids probate. And a revocable trust is basically, it is a document, just like a will is a document. The revocable trust also dictates what you want to happen to your stuff when you die and who you want to take care of it. But the difference is that with a revocable trust, after you sign it, we actually help you retitle assets. And we go over all of your assets with you and make sure that we retitle certain assets so that they are actually owned by your revocable trust. And while you are alive, you are the trustee. It's under your Social Security number. You are the beneficiary. So it's really an alter ego. It doesn't change anything about your tax filings or your ability to use your money or sell your property. You can do whatever you want with it. But at your death, it becomes irrevocable. Your successor trustee steps up and they carry out the terms of the trust. They look to the page that says, when I die, this is what I want to happen, and they do it. And because the assets are owned by a trust and not an individual, there isn't anything that has to go through probate. So that's a quick and dirty review of what a revocable living trust is. The reality is it is more cost effective in the long run than a will and probate. The reason that many young families and young parents do not choose to do the revocable living trust as their first estate plan is because it comes with more cost up front. The cost savings for the revocable trust is in the long run. But up front, it does have additional cost because it is more complicated and it is more work. So for many young couples, the reason that I really focus on just go ahead and at the very least get a last will and testament in place is because for many young couples, they own most of their assets jointly. So avoiding probate really means both of them would have to die. And most young couples are planning and gambling on the risk that that won't happen, and so that they can always shift to a revocable trust plan at some later date. Now, I'm not necessarily saying that that's what I recommend or that's how I guide people, but I understand the decision-making that goes into it. And for many young couples doing their first estate plan, it's a matter of let's just go ahead and get the documents in place to protect against the worst case scenario. Now you'll see that the revocable living trust, I do mention that a last will and testament is also part of a revocable trust plan. That's true. The purpose of it is to be a safety net to catch an asset that may have somehow not been retitled into the trust, or however it is that it was missed, and it goes through probate at death. We want to have a will in place to say that the probate estate pours over into the revocable trust, because the revocable trust is really where the terms are dictating what you want to happen to your property at death. And therefore, because a will is where you name the guardian of your minor children, you will have a will in either doing just a last will and testament as your death planning document, or if you choose to implement a revocable living trust. Now, a really important thing when we're talking about planning for your children, not only is it with regard to designating whom you would want to be the guardian of your child's physical well-being. It's the person who will actually be in charge of making sure that your child goes to school and goes to the doctor and all of those aspects of physical well-being. But it's also relevant with regard to how you would want your children's inheritance to be handled. Who do you want to be in charge of the money that's being left for your child? And what are the parameters regarding how that money is used? And so on and so forth. So some of the topics that are important to talk through not only is who do you want to actually be responsible for your children, for their physical well-being, but do you have any additional specifics that you want to provide guidance on regarding sports that you want them to be involved in? Do you want them to be able to travel and see the world? Are there cultural experiences that are important to you that they are exposed to? Is it important to you that they somehow manage to continue to live in your family home and that they're raised there and keep going to the same school system? All of those are details that are able to be written into your documents and that I highly recommend. And that's information that not only you could put in the will, but that really would be appropriate in a separate letter. Again, that letter of instruction that I mentioned with regard to your own personal health and well-being. I want to listen to classical music. I want to eat vanilla ice cream. That's also something that's really important for you to be able to go into a bit more detail about what type of life you want your child to have if you were to die before they were 18 years old. But then it's also really important for you to think about and dictate, is it the same person that I want to be in charge of my child's physical well-being as well as the money that they inherit from me? Or do I want that to be two different people? And that's a counseling issue that we talk through because there are pros and cons to different ways of doing things. And depending on how you want that inheritance to be used, and at what age would you want your child to actually be able to be the recipient of the inheritance? Under the law, 18. At 18, you're the age of majority. You're allowed to actually have your own money and your own assets. But most of us know that at age 18, that doesn't necessarily mean that you're financially responsible or mature. So do you, as the parent, want to build in some parameters for further controls to outlast the age of 18? And that's something that you're really only able to do if you build it into your documents. And absolutely vital is to talk about, do you have a child who has any sort of special needs? And that's something that's important to talk about because at that point we're talking about how should an inheritance be structured in order to make absolutely sure that it provides for your child's needs while also protecting their potential eligibility for government assistance. If they are not able to work or if they need government assistance, we want to make sure to maintain their eligibility for that while still having the benefit of any money that you leave for them. But that's something that has to be structured properly and precisely, and which can really only be done with the appropriate planning. So the point of all of this is how important it is to put it in writing. An estate plan is simply a way to have all of your thoughts and intentions and concerns and goals written in such a way that they will actually be implemented and enforced if the worst happens. So I do want to mention Elville and Associates recognizes that many young people and young families, number one, have not ever gotten around to creating an estate plan. I believe that the main reason for that is there are a lot of other things on the to-do list, and this does not always fall near the top. Another reason for it is, of course, the cost. So in recognition of that latter part, which is what we are able to help with, we do offer a low-cost, flat-fee plan that's intended to help people who are just starting out and just getting their first estate plan into place and who have not accumulated significant assets yet. This plan will cover getting you an advance directive, the financial powers of attorney, and a last will and testament, so that you know you're protected if the worst happens, and in the future we can build and update and change and get into more complicated planning depending upon your preferences, but at the very least getting these fundamental estate planning documents in place. And that's as much as I have to cover today. I know that was a significant amount. Any further questions?
We do have some, Olivia. Thank you so much. Going back to the MOLST to begin with, is a MOLST something that a doctor's office must prepare?
Good question. And the answer is a MOLST can only be signed by a physician, but it is not something that every person has or that every doctor's office is required to provide or prepare for their patients. So what I mean by that is a MOLST is only effective if it's signed by a doctor because it is a medical order. But the times where it is mandatory that it be signed and that it exist are limited to certain situations, such as being in the emergency room for an extended period of time, or being in a rehab facility for an extended period of time, or certain other specific situations. It is mandatory that your file, when you are in that medical situation, your file at the foot of your bed or whatever has to have a doctor's order signed MOLST, basically saying if this patient codes, do we resuscitate or not? So there are only certain situations where a MOLST is required. What I recommend is that you talk to your physician about it, and what you are able to do ahead of time is something called the Healthcare Decision-Making Worksheet. And that's a form that you're able to fill out, basically letting the doctor know if there's ever a situation where it's mandated that a MOLST be signed and part of my medical file, this is how I want the MOLST to be completed. These are my preferences with regard to CPR and various other things. So that I recommend going over with your doctor. And again, as part of working with me, I'm able to provide you with samples of what those forms look like.
Thank you, Olivia. Another question. Does a spouse have to go through the probate process if I have assets that are not joint, like a 401k account through work, but the spouse is the beneficiary?
So the answer to that is no. So if you have a 401k that is beneficiary designated to your spouse, that is not an asset that will have to go through probate.
Very good. Another question. Where would the money come from to pay creditors if all assets did not go through probate, but through the ownership or beneficiary designation?
Right, good question. So the reality is that when someone dies and there are valid creditors' claims, and that's the starting point, are they valid? So if there are valid creditors' claims, then the question becomes, what is the source of money for the creditor to claim against? And the creditors are really able to claim against probate assets or revocable trust assets. So people often think that a revocable trust is shielded from creditors, and that is not true. What creditors are not able to claim against are assets that were beneficiary designated or that were jointly owned in certain ways. So to be clear on that, there's a certain type of ownership that's available for spouses, which is called tenants by the entirety. And it's a form of ownership that shields the asset against creditors of one spouse. So if assets are owned with your spouse as tenants by the entirety, at your death, your creditors don't have rights to claim against that. But let's say you jointly own assets with your sister or a friend. That is something that asset would not have to go through probate, but creditors would have the ability to claim half of it or claim against half of it. Your joint ownership is treated as you owning a portion of it, and that would be an available asset for creditors to claim against.
Very good. Another question, doesn't having an asset like a mutual fund or a CD, 100% beneficiary designated, also avoid probate?
Thank you. That is a common question and a common approach, and that's actually something that I will say. I have many clients who their financial advisor maybe guided them. You don't need to do a revocable trust. You can just avoid probate by making everything beneficiary designated or payable on death or transferable on death. There are certain complications and risks that can arise in those types of structures that can be avoided by doing something with a revocable trust. And an example of that I will give you, first I will say it is impossible to avoid all risks. We all know that. That's just the reality of life. So you cannot guarantee that you will avoid all risks. But what you are able to do is minimize the risks. And that's why I don't recommend making all of your assets POD or beneficiary designated in order to avoid probate. I would recommend doing the revocable trust if your goal is to avoid probate. And the reason that I say that is 2 examples of risks that I'm talking about. You make an asset payable on death. Let's say it's your brokerage account. You make it payable on death or beneficiary designated. Well, what if when you die, the person that you made it payable on death to has had an accident and now they are incapacitated and not capable of managing money for themselves and receiving government assistance. And now they inherit a chunk of money from you without any parameters built in about how the money is held or how it's used, and it leads to a very complicated mess where you're potentially ruining their eligibility for government assistance, which is something that could have been avoided if it had been held in your revocable trust, because there are all of these contingency provisions built in to catch an inheritance if the beneficiary is dealing with situations like that. They're receiving government assistance. They would lose it if they inherited this money. What's another option? That's a contingency that's built into a revocable trust, which would not be addressed if you simply made it payable on death to that person. And another risk is, what if that person has died? What if that person died and you never got around to updating your POD, or you were incapacitated and couldn't update your POD? Now your asset at your death is going to a beneficiary who's deceased, which means that now their estate maybe has to be probated and your money goes to their estate, which was not your intention. Or it means that you actually have to have an estate opened and probated because there is no beneficiary to receive your asset. And if you don't have a document in place to guide where that probate estate goes, it may not go where you want it to. So there are just a lot of things that, yes, there may be shortcuts or what is seen as simple ways of doing things, but they can lead to a lot of risks and a lot of messes that can be avoided by doing things in a bit more structured way.
Thank you, Olivia. Another question. We do have a few here. Can you have minor children as secondary beneficiaries just in case the asset owner and the primary beneficiary die simultaneously? For example, both parents die together.
So absolutely. I mean, certainly minor children can be beneficiaries and minor children can be, they can inherit. It's just that it can add some complication if there is no document in place controlling how that inheritance is handled. So the kind of worst case situation is that a minor child inherits an asset and there's no structure in place for how that asset is controlled or owned or held until the child is 18, which leads to the need to get the court involved and to open up a guardianship for that asset for that child. So yes, you absolutely can designate your minor children as beneficiaries or set it up such that they would inherit if you and your spouse both died. But it's important to have documents in place that would address the structure of how that inheritance is controlled and handled and by whom.
Another question, Olivia. Why do you want to avoid probate? Is there any circumstance where you do not want to avoid probate?
Well, the reason that most people who want to avoid probate, the reason that is offered is I don't want to have to, and again, I'm not talking about me because I would be deceased, but I don't want the person who's dealing with things after I die. I don't want them to have to deal with the court. Many people have an aversion to any sort of interaction with the court. I would say that's warranted. For better or worse, they do the best that they can, but it's not ever an ideal situation. So avoiding probate means avoiding interaction with the court and avoiding interaction with a government county office and the bureaucracy involved. Avoiding probate means avoiding the fact that it's public. So probate is a public proceeding. Truly, anyone can come in off the street, and actually now you can just order it online, and request a copy of the will or request a copy of the accountings. They can request any of the information that's part of the probate estate. It's entirely public. And so sometimes people really want to avoid that. And especially if there is any element of disinheriting someone or any concerns that someone is going to cause trouble because they disagree with how you've structured your estate or they disagree with what's done, they will have an easier time of challenging it if it's going through probate, because at that point it's already in the court. It's already part of the court system, and so it's easy for them to submit a challenge. Whereas if you've avoided probate, that person will have to go through a lot more effort and pay a lot more to bring any sort of challenge. So avoiding probate is avoiding the court, avoiding the bureaucracy, avoiding the public nature of it, and the fact that probate does tend to cost more than a revocable trust administration. So very quickly, the way that I always kind of summarize it, a will is less expensive up front because it is more costly usually, not across the board, but usually after death. Probate is more expensive, whereas a revocable trust is front-loaded. You are paying more and you are doing more work and it is more effort, and you're saving that cost and saving that work on the tail end. And that resonates with a lot of people, choosing to do it up front or leave it at the end. And again, you make different decisions throughout life based upon competing priorities and all of the circumstances. But that's why people tend to want to avoid probate, or they've dealt with their parents' estate, or they've heard through pop culture, oh, probate is awful. And again, it's not the end of the world. It's much better than it used to be, but it's certainly not a walk in the park.
Okay, we have a few more. Lots of great questions. I think these are the most questions we've ever had on a webinar, which is terrific. So we have two questions, actually. I'm going to try to combine them. So if someone has a serious illness and is single, do you recommend a revocable living trust? I know that might be a counseling issue, Olivia, but also to go in hand with that, what cannot go into a revocable trust? Untitled assets like bank accounts or retirement accounts?
Okay, great. So the first part of the question was, would I recommend a revocable trust for someone who is single and has a significant illness?
Yes.
Was that the first part of the question?
Correct.
So that is something that would require a bit more conversation and a bit more counseling. But generally speaking, I would say that my answer would be yes. And actually, I'll just go ahead and be honest. Generally speaking, I almost always, not always, but almost always am on the side of recommending a revocable trust as part of the estate plan for most people. It just depends on at what stage in life and what people, again, the competing priorities of cost and complication. But for the most part, a revocable trust is something that I recommend just because in our practice, we are intimately familiar with what it is to go through probate and what that entails and how complicated and burdensome and expensive that can be. And we are also intimately involved with seeing what it is to administer a trust and how much more streamlined and less costly that can be. So I almost always encourage revocable trust planning. It's just that clients have to determine whether now is the time. But yes, for an individual, and that speaks to many times people say, I'm not married, so I don't have a spouse that's going to be able to handle everything for me. And I'm worried about that. And I'm going to have my sister handle everything if something happens to me. And she lives in another state. And I don't want this to be a burden for her. Well, that really speaks to a revocable trust. Number one, if someone's in a different state, it is a pain for them to qualify and to be able to do what they need to do with the Maryland court and the Maryland specific county. So it's almost always easier for someone out of state, if they're going to be handling things, to be able to do so through a revocable trust plan. So that's how I would answer that question. Convoluted, but hopefully made some sense. The second question is a bit easier. So that is accurate. Not all assets are retitled. We cannot retitle qualified retirement accounts or qualified accounts. We cannot retitle those because there are tax consequences. So we don't want to mess with the taxes. We don't want to trigger the taxes. So for 401ks, 403bs, TSP, IRAs, a lot of annuities, that sort of asset, we do not retitle. Those are handled by beneficiary designation. And the same with life insurance. We do not retitle that. Those are handled by beneficiary designation. And usually when we work with clients on the revocable trust, we don't want them to have to deal with the headache with their checking account of having to update all of their automatic debits and automatic deposits. It's a nuisance. So we simply leave that in their names and have them make it payable on death to the trust. And that will avoid probate, and we're okay with doing it that way because most people's checking account is in and out every month. They get their income, they pay their bills. So it's not accumulated to some massive amount. And so we leave that as it is, make it payable on death to the trust. But pretty much everything else we recommend and we work with clients to retitle. And that's another big thing that we offer, is actually making sure that all of your asset alignment is done properly. We help you make sure, no matter what type of plan you put together, we help you make sure that all of your assets are structured properly to flow according to that plan. Because otherwise, your plan is incomplete, and that's not fair to you.
So just a few more here. Thank you, Olivia. Can you reiterate the difference between a will and a pour-over will?
Yes, absolutely. A last will, and so either way, a last will and testament is a document that dictates where your probate estate goes, meaning to whom, and who handles it, which is called the personal representative. It's just that a last will and testament by itself, when it's not part of a revocable trust plan, a last will and testament that is its own standalone, this is my death document, for lack of a better phrase, that type of last will and testament dictates where you want your probate estate to go. So to my children, to my siblings, to these charities, whatever your preferences are. And it dictates how I want my children to receive in inherited irrevocable asset protection trusts, or I want my children to inherit in a supplemental special needs trust to protect their eligibility for government assistance because they probably won't ever be able to work because they have special needs. Or I want my children to inherit in trust and my sister to inherit outright. It's hers, whatever she wants to do with it. That's what an independent, standalone last will and testament does. It goes through probate and it controls where your probate estate goes at the end. At the end, it goes to your children, it goes to your sister, it goes to the charities. The difference with a pour-over will is that it also controls your probate estate, and it also says who your personal representative will be, but the beneficiary, where the probate estate is going to end up, is your revocable trust. Because it's inside your revocable trust that you've said, I want it to go to my sister, my children, and these charities. So the purpose of the pour-over will, first and foremost, if you do a revocable trust, our job is to help make sure all of your assets are structured properly to avoid probate. And if that's done successfully, when you die, that pour-over last will and testament has no purpose. It's moot. But just in case something was missed or something was forgotten, and when you die, that will has to go, or I'm sorry, when you die, that asset has to go through probate, we want to make sure that you've got a will that will kick in and will direct that probate estate to funnel through your revocable trust, because your revocable trust is really where you put the terms regarding how you want your estate to be distributed. So I hope that was helpful. And either way, that's where you would designate the guardian of your minor children. That's where that would be written.
So 2 more, Olivia, then I think we'll be right up at 1:30, which is good timing. Are there any assets that you would not retitle to put into a revocable living trust? I think you answered that question. Along those same lines, if an asset is not able to be retitled, is it still in the revocable trust?
No, so an asset is only in the revocable trust if it's either titled in the name of the revocable trust, or after death, if you have beneficiary designated it in some way. So certain assets, as I said, we don't retitle certain assets while you are alive because there are negative tax consequences, such as retirement assets and life insurance. At death, the point of all of it is we want to make sure to avoid probate, and we want to make sure that your assets are going to go where you want, to whom you want, in what way you want. And the way that we accomplish that is step one, we talk to you and figure out what is it that you intend? Where do you want your estate to go? To whom and how and where? And then step two is helping you structure your assets in accordance with that plan. Whether that means retitling assets so that they are owned by the revocable trust, or helping you update the beneficiary designations on retirement assets and life insurance to make sure that those flow according to your plan. So your main job as the client is to figure out, where do you want your estate to go? And people typically think of their estate as one bucket full of all the assets. And our job as part of the estate planning process is to start by helping you pin down, where do you want your estate to go at death? And then we help you structure your assets accordingly. And if part of your plan and your preference is to avoid probate, then part of that process is to do it by way of a revocable trust. But structuring all of the assets is nuanced and is part of what we help you do.
Very good. Another question. So that my 18-year-old child does not, quote, win the lottery, unquote, upon my passing, would you recommend setting up a trust fund that my assets would go into and be released to him upon a certain older age?
Absolutely. Absolutely. Even the most financially responsible 18-year-old, I recommend that there be some sort of structure to the inheritance. And something that I will say is that even the most financially responsible 65-year-old could still benefit from something called asset protection. And so usually when people are thinking about their children, and especially if they're minors or 18, usually people are thinking about it in terms of, oh, my child is definitely not financially responsible or mature, so they would blow the money if they won the lottery. But a different angle to think about is, at any age, even if you're the most financially responsible, there are risks out there that you are at risk of where you could lose money, two of which are divorce and getting in a car accident. And if you get sued because you skidded on the ice and caused a car accident, and the jury says, we don't like the look of you, here's $1 million, and your creditor comes after your assets and says, you owe me $1 million, that can happen to anyone at any age. We are able to actually create structures where you can guarantee asset protection even if your child is 50 and at that point, hopefully financially responsible, but they could still benefit from asset protection because of those risks that all humans face. So the answer is yes, there are ways to structure an inheritance to be protected against a young, financially irresponsible person, but also to be protected against the threats of the outside world.
Last question, Olivia. For minor children who are beneficiaries, you said there needed to be other documents. Would this be a will that appoints a guardian for the children or something else?
Yes. So at a minimum, the answer is yes. That if you have your minor children, if there came a time where minor children inherited an asset, it will be relevant and important and necessary that a guardian of that asset or a guardian of that minor child's assets is named. And so your choice is either that you sign the necessary document where you've named who that person would be. If you don't do that, and if you don't have that in place, then if that were to ever happen, it means that the court appoints the guardian of that asset or assets. So yes, that is what I would recommend. With all of this, the point is you probably have your own preferences. You probably have your own thoughts about who and how and what. And the only way that you have of making sure that that's what would actually happen is if you have it in writing in the necessary documents.
Very good. So Olivia, it's my turn to ask a question, and then we'll wrap up. In this age where, it's still hard to get out, and, we're obviously open as an essential business and have been staying very busy. Can you talk from your perspective as to what your meetings with clients have been like for those that may be interested in setting up a free consultation or having documents reviewed? What does the process look like at this point in time for meeting with you?
Thank you. Yes, Jeff, absolutely. Well, so we are extremely lucky in light of a very unlucky and unfortunate reality right now. Technology, as imperfect as it sometimes can be, technology is allowing us to proceed fairly well as normal. So what I've been doing is conducting meetings virtually. If people have access to a computer with internet and a camera and a microphone, we're able to have virtual meetings where we can see each other and hear each other and practically be in the same room. So free initial consultations, let's talk about your specifics, your family, your worries, your assets, all of that, and then talk about what your options are, and I can help guide you on what might be the best option based upon all of those circumstances. And then moving forward, it's a matter of, we have document review meetings, again, using the computer. I do work with clients who don't have access to that technology, and we manage. We work around it as best we can, whether it means mailing things and having phone conversations. Whatever it is that we need to do, we're able to accomplish. But it's very simple if you do have access to a computer and the internet and a camera and a microphone. It's pretty seamless. And we're even able, even in light of stay-at-home and quarantine and all of those realities, the governor has issued several emergency orders for this period of time where we're able to even accomplish document signings without being in person. And that's a pretty remarkable thing that's allowed us to really proceed and get things done and get estate plans in place, even with these very odd circumstances.
Very good, Olivia. Well, thank you so much. I think we can give Olivia a virtual hand for a job well done. And thank you to all of you for your excellent questions. Really thought-provoking and elicited a lot of great responses from Olivia that I think helped everybody on the call. So with that, I think we'll go ahead and wrap up today. You were sent, along with the presentation for note-taking purposes, a comments and consultation form in your email this morning. I'm sorry. If you could take just a couple minutes to fill that out, offer us your feedback about today's presentation. What you liked, what we can improve upon. We're always looking to, perfect our processes here at Elville and Associates. And if you do have an interest in meeting with Olivia for a review or just to get started, dip your foot in the water, send that back to us or just email Olivia or me, and we'll be happy to work with you and be a resource for your family and you. So I'll also be sending out a video of today's event to you if you wanted to share it with your family and friends, as well as some other information about some other upcoming events that you might be interested in. So thank you again. We appreciate your time and your interest in Elville and Associates. Hope you have a pleasant day. Take care.
Thank you.